Property aims to foster an environment in which creativity and innovation can flourish. One such intellectual property is patent. To throw light on this emerging topic of patent law, we have organized today's webinar. I, Pratibha B., Assistant Professor, on behalf of Vivekananda College of Law and Institute of Janata Education Society, warmly welcome all the participants with special reference to the heads of various institutions, faculty members, advocates, alumni, and students of all institutions to this webinar series on intellectual property rights. It is my pleasure to welcome our esteemed speaker of today's program, Dr. Kavyashree N., Assistant Professor, Government Law College, Ramnagara, who has accepted our invitation to deliver a special lecture on undertaking the relevance of patent law in technology-driven law. I feel happy to present her brief profile. Dr. Kavyashree has obtained her bachelor's and master degree in law from University Law College, Bengaluru. Initially, she started her profession as an advocate. Later, she shifted her interest towards teaching. She has rendered her services as an assistant professor at Bangalore Institute of Legal Studies and later at University Law College, Vishadharapuram Law College, Bengaluru. She obtained her PhD under the able guidance of Dr. T.R. Subramania, former Vice Chancellor, Karnataka State Law University, Hubballi, in the area of intellectual property right on patent and pharmaceutical industries. She was appointed as Assistant Professor of Law at Government Law College and presently rendering her services as Assistant Professor of Law at Government Law College, Ramnagara, and also as Nodal Officer, Bengaluru. She has participated in many national and international conferences and has presented research papers on various topics like constitution, labor law, criminal law, and family law. She has chaired national and international conferences on law. With this brief introduction, I once again welcome Dr. Kavyashree N., Madam, to today's lecture. Over to you, Madam.
Thank you.
Thank you.
Good evening, one and all. I think I'm audible. I'm audible,
Yes,
ma'am?
yes, madam. Yes, madam.
Yes, you are audible, madam.
Yes, ma'am.
You can
Thank you
continue.
for such a nice introduction. And let me start this topic without wasting much time. Due to technical problem, I am not able to join through laptop and share the PPT, but I will be doing later on. We have to speak the concept of patents and linking with IPR as such. So this is the first session of the webinar. Let me briefly introduce all of you to the concept of property and intellectual property and patents. And whenever we study patents or whenever we learn patents as such, so we always think this is a purely technical aspects, and we feel we may not be knowing because this is basically science and involve lot many things, lot many inventions, technical aspects, chemical reactions, and all those things. But when we are studying as a law students, we will be concentrating from the point of property, from the point of intangible property. Intangible property means exactly all this, as we have studied in jurisprudence, what is property. Property is nothing but bundle of rights and all those concepts. And when we speak of this concept of intangible property from the point of intellectual property, here this is intangible as well as intellectual, and which is useful for the society. And any person who has got property rights, because we always ask how patent is a form of a property. Is it any concept of proprietary rights are there, property rights are there? So we always speak from the aspect of, yes, this is giving rights, rights in the wider sense for the person who has invented to enjoy all the proprietary rights. So when we speak of patents as a form of intellectual property, this is not something joke or anything for any person, inventor who has spent a lot of time in inventing and has made the concept of any new invention. It can be any product or any such kind of new which is useful for the society. He has spent a lot of labor, hard work, and all that particular labor, hard work has led him to make that particular property for exploitation, commercial exploitation, economic exploitation, because he has put all his hard work. Okay, so with this linking of particular concept of IPR and patents, we're going to start with the concept of patents. Okay, patent, as I told you, It is purely an aspect of invention. And what is the necessity of concept of patents and why it is important? What is patent means? It's actually literal meaning. If you take the meaning of patents, it's just letter of patents, which was practiced during the time of the Britishers. And very simple aspects. It's a document, technical document, giving the property rights for the person who has done invention. If you go back to the history of patents, or if you go back to the history of intellectual property rights, we have to go to the Industrial Revolution, which took place during the time of Renaissance, Reformation in Europe, very which case led to the many and many of new inventions. So such kind of new inventions has to be protected, and the new inventor has to get his hard work, and all the particular aspect he has to be protected, and he should be rewarded for whatever the benefit. So in that particular aspect, when we speak of the patents, it's purely an letter of document, literal meaning of patents. But when we have taken into the concept of patents and invention in India, if we go back to the history, what was the first patent legislation, how the concept of patent started, history of patents, we have to go back to the Britishers. So during the time of the Britishers, as all of us know, most of our laws was made and drafted during the time of the Britishers, and they will be having the impact of the Britishers and Britishers laws, especially British laws. Okay, so even the patent law is not out of it. And before this Patent Act of 1970, we used to have the legislations of Patent and Designs Act of 1911. And before having full-fledged act after Indian independence, we have got a committees which was made, and which they started for having tried to make one legislation compiling and covering all the aspects of patents. Okay, in that particular aspects, we will be having this Patent Act of 1917. And there is always a link of the concept of Patent Act and how it is rewarding the hard worker and all. And if you look into the Indian Patent Act of 1970, it has totally 23 chapters, and it speaks about the concepts of patents, how it should be, and what is patent, what is an invention, how it should be protected, what are the rights, remedies, infringements, and international conventions, and how it can be revoked, and what are the compulsory licenses. All those concepts, this 23 chapters it is covering. So when we speak of the patent law in India, what is the objective behind Indian patent law? So if you look into that, we have to go back to the case law of Bishwanath Prasad Radhesham versus Hindustan Metal Industries. Though it was of 1979, it has stressed the importance. Supreme Court has told what is the object of patent law, what should be the object, what should be kept in the mind of a innovator or inventor who is going for a new invention. It says the object of patent law is to encourage scientific research, new technology, and industrial progress, grant of exclusive privilege to own, use, sell the method or the product patented for a limited period, stimulates new inventions of commercial utility. The price of the grant of the monopoly is the disclosure of the invention at the patent office, which after expiry of the fixed period, it passes into public domain. So this is the basic object of patent law in India. So it means what? Patent is given for a new invention to promote more and more research and technology and for industrial progress, and that's only for limited period. So we may think that we are giving exclusive right for how many years and all. So it's nothing of that sort. Patent is only for 20 years as of now. We have got 20 years of patents, which is there presently. Why it is only for 20 years? After 20 years, the information will fall into public domain. All the public are access to use and know what is the contents, or what are the contents of the claims or of the inventions which has been invented. Okay, so if that is the case, we are not giving any kind of lifetime property rights in the case of intellectual property rights. Is the same case applicable for patents also? So this case law always stands to speak about Indian patent legislation to know what exactly are the objectives of Indian patent law. Okay, so if we have to know what are the principles underlying Indian patent law means, whenever any person means true inventor, applicant who wants to get patent under Indian Patent Act, he should have got a novel invention, novel involving inventive step, and it should be of industrial application. So what do you mean by that? Means it should have an invention, inventive step, and capable of industrial application, and must be useful for the public as such. Okay. So what do you mean by these particular aspects? Means whenever you might have invented anything, if it is not of novel, if it is not of useful, if it is not something new to the world, there is no point in giving a concept of patents to you, reward to you, enjoyment for whatever you have invented as a property as such. So in that particular aspect, if it is not having any inventive step, our judiciary and all Supreme Court decisions have defined what is inventive step, and it should have inventive step. If you don't have inventive step, it's not capable of going for patents as such. Inventive step means it cannot be the same old whatever which was earlier, and you are just altering, modifying. Frivolous? No, no question of such kinds is allowed. For the concept of patents, it should be a purely having novel and inventive step and capable of industrial application. And we may say many times, yeah, I have invented this, I have invented that. Is it industrially capable of manufacturing, commercially producing? Because ultimately, whatever your hard work you have done, you have invented, that particular concept of property should be commercially exploitable. It can be commercially exploitable and can reward to the person who has invented. Otherwise, it's of no importance at all. Okay, so when we speak of patentable invention, as I told you, it can be new product or process and must be non-obvious and must be useful, must be capable of industrial application. Why we speak of non-obvious? Non-obvious means any person technically good in that particular field may not be able to identify what is the logic or what is the reason, what is the technical aspects, how that instrument is working. So in that context, whenever we speak of the patents, we think we have to say that it should be non-obvious. If everything is noticeably seen, can be feel, there is nothing secret, nothing we feel, hey, everybody can understand. What is great in that? So nothing of that sort. Okay, so it must be new product or process. Earlier, Indian Patent Act of 1970, we used to have the patents given for products as well as process. There was no particular limit as such. But now, after 2005 amendment to the Indian Patent Act, we have to make particular aspect of Indian Patent Act is for product and not for process. So we must be knowing what are product patents and process patents. You can understand when we speak of product means complete product. We are taking an example, and that product cannot be used or any kind of cannot be manufactured without the permission of the patent holder. This is the present product. But when we speak of the new process, we can have different process of manufacturing a product, and ultimately a product can come. See, we have got calcium tablets, we have got many kinds of medicines which has been produced by different kinds of manufacturers. Ultimately, the contents and almost all are similar. Products is also similar. Process may be different. So when we speak of the process patents, it is earlier Indian patent law was flourished like anything. It has made money, minted money and profits and welfare also. And we used to supply huge quantity of medicines for African countries because we used to copy or we used to make the reverse engineering methods of processes of the other developed countries and used to make the finishing products. But now, after 2005, we cannot do this because we have got product patents and no question of process patents is allowed. So that's one of the drawbacks. you have to wait till the closing of the particular patent period for reverse engineering, or you have to take the license from the manufacturer, that is the patent holder or anyone who has got a right to manufacture, then only you can manufacture. Otherwise, you will be called as infringing, coming under the definition of infringement of patents. Okay. So when we are studying the Indian Patent Act of 1970, section 3 and 4 are very important, because when we speak of what is invention, there are certain exceptions given under the act, say that though it look like it is a invention, but it is not given any status of invention, and that is not patentable. We have a list of the points which says about what are those points, and I'm going to give you a few. We have got sufficient points which says that what has to be called as invention, especially those inventions which are injurious to public health and frivolous and which violates public morality, and all those things are not inventions. And if it is any aspect of any aspect of the particular case law, we speak of the particular aspect of inventive process treatment, and mere discovery is not given, and the process of treatment to human beings and animals and plants are also not given, and especially medical, surgical, curative is not considered as inventions, and traditional knowledge is also not considered as in patents, and also computer programs, mathematical calculations, and all those things will not be given as inventions. Okay, so here we can understand computer programs, softwares, I had as a point of it, softwares are patents or copyrights. So softwares are copyrights in India. It is protected under copyright law, and it is not a patent under Indian Patent Act. So that's why here it is, we have excluded from the definition of patents and inventions all the particular computer programs and softwares. Okay, so when we speak of all these aspects, inventions and all, who can apply? Who can apply for patent means any applicant who is a true and first inventor. What do you mean by true and first inventor means? For example, if I have to file an application for the sake of patents, I should be the first one who has invented and applied for patents. If already information is there, public knows the information, that cannot be called as patent at all. That cannot be called as invention at all. So for the better understanding of the patents, the first and true inventor is the person who has invented which is not known to the world. Not known to the world is always very important. If it is known, I don't think so that can be novel, and that can be coming under the definition of patents as such. Okay, whenever we speak of this particular aspect of patents, as I told you, so excluding the exceptions under section 3 and 4, if it is any aspect of patents, it is applicant can always file an application. There is a procedure, and any information relating to intellectual property rights, especially patents, how to apply online, we can log into www.ipi.india. So this ipi.india will going to give you all the details about intellectual property rights, statutes, policies, and other forms of intellectual property rights like copyrights, designs, and other aspects of GI, and what are the latest policies, latest updates, everything you will be getting under this particular website as such. Okay, that's the authenticated and standard information, and that's a standard source of information also. Okay, so nowadays we have got online application that can be processed and file an application with a brief description of your invention. So brief description of your invention means whoever as a person who has invented can file an application. So for example, if there is any company and employee, then who has got a right to apply for an application is important. For example, if company and employee has any kind of understanding or contract or agreement between them, whatever is doing research will go to the company, then he cannot file as a applicant for the true and first inventor. The company is getting the rights. And is this done, the course of invention is done in the during the time of the company working hours or not. That also is counted, because if it is done, if it
Good
is
evening,
done
ma'am. I
during
have
the,
a small doubt.
yes, ma'am.
Ma'am, can you please send one petition copy
Yes, ma'am.
of anything which is related to Patent Act, ma'am?
Yeah, you want the petition copy of Patent Act,
I'm sorry,
or
please.
no, you want the patent copy of the petition copy.
The petition copy related to Patent Act.
Exactly, with respect to what, madam?
Anything which we could patent it, and
Okay.
and also challenges with respect to it, and any concern which we can bring up at the later stage. Hello.
Jivita?
Yeah, ma'am.
Please
Yeah,
wait for the interaction session.
yeah, there is an
Jivita?
interaction session, so you can ask the queries there. Let madam finish her presentation first. So later on, we can go for an interaction session. Okay?
Sure, ma'am.
Please don't speak in between. Don't disturb the speaker. There will be interaction session. Queries can be brought there.
Okay.
ma'am.
Kaveshri madam, sorry for the inconvenience. You can continue.
Brahmachari, please stop presenting. Yes, madam, you can go ahead. Kaveshri, madam.
ಅವ್ರದ್ದು ಡಿಸ್ಕನೆಕ್ಟ್ ಆಯ್ತು ಅಂತ ಅನ್ಸ್ಕೊಳ್ತೇನೆ.
Yeah, I think her call is disconnected.
Disconnected, yes. She's not there in the list. ಮೇಡಮ್ ಯಾರಾದ್ರೂ ಕಾಲ್ ಮಾಡಿ ಅವ್ರಿಗೆ, ಸುಭಾಷಿಣಿ ಅಥವಾ ಪ್ರತಿಭಾ.
ಬಿಸಿ ಬರ್ತಾ ಇದೆ ಮೇಡಮ್.
ಓಕೆ, ಹಂಗಂದ್ರೆ ಯಾರೋ ಮಾತಾಡ್ತಾ ಇದ್ದಾರೆ. ಓಕೆ.
Yes, madam.
Bhuvneshwari madam, Indrani,
Yes, ma'am.
could she not join?
No,
I
madam.
don't think she could join.
Okay, I think she's joining in some other link.
Indrani madam, are you here?
I think, yeah, Kaveshri madam has joined back.
Okay.
Yeah. Kaveshri madam,
Okay.
please continue, madam.
Yes, ma'am.
Thank you.
Ma'am, someone was asking about a doubt. Let me clarify that and go.
No. You can clarify
No,
in
there
the...
will be interaction session.
Yes, madam.
Okay.
After your lecture is over, there will be
Okay.
time for interaction.
Okay, ma'am. Because she started asking about petition,
Okay.
so I thought let me clarify and go. Okay, I'll complete it. Later on, we can speak to her.
Okay,
Yes, ma'am.
okay, madam. Thank you.
Yes, ma'am. So I was speaking about the concept of the particular aspect of procedure for obtaining patents. When we speak of procedure for obtaining patents, we always take applicant, who can an applicant and who can file an applicant, and what is the form. As I was speaking about that, you should be true and first inventor, the first one, and which country you are from where you are filing an application. So that's always important. If I am from India and my invention is from India, I have to file an application from India, and to seek the protection first under India. Then after last session of this particular class is about PCT. That is, through PCT we can get the protection throughout the worldwide. That is Patent Cooperation Treaty. Okay. So when we speak of this particular applicants, there are different forms of applicant. Are you from a convention country, or are you from India? And that application has to be filed in patent office, and it should have provisional specification with your application. What do you mean by provisional specification? Means this is a description. This is known as a technical document actually. Basically, it describes what is your invention. It's about what and what are the brief steps of invention, how it is useful, and what exactly your invention is speaking about. So it should be in a very abstract form that will be given in the specification, because any inventor will not wait till the last time, till the last of completion of the report and go for patents. As soon as he get an idea, he starts inventing certain things. He'll file this. He'll file an application with specification. So when we have the specification in the beginning of it comes under section 9 of the Patent Act, which speaks about what are the technical documents and technical details he has put forth. Because the date of the application is always considered for granting of the patents. So later on, you'll be given the time period to submit complete specification. That complete specification is a purely an extension, addition. Whatever you have started, you might have come to an end with much more claims, much more points, much more additions. So what exactly should be there in the beginning, it can enhance by the end of your submission of complete specification. So after complete specification, that particular specification and details are furnished to all the persons, and especially at the patent office. Once this is done, once this is got, they have to examine. You have to request them for examination of our application. And once it is examined, cross-checked and communicated, then it will be published. Then it will be publication. Publication means any opposition, pre-grant and post-grant. If any person is opposing, for example, I might have applied, copied somebody's patents, copied somebody's idea, and copied somebody's invention, he can always oppose. He can always oppose before the grant of the patent and after the grant of the patent also. So when we speak of this particular aspect, it's always important what are the powers of the controller of the patents with respect to application. He will going to examine publication, and then we're going to have the opposition proceedings for grant of patent. On what basis you can oppose means we already knew the information, and this is something not new. This is frivolous. You might have copied from others. So any kind of such information you have to substantiate with sufficient evidences and documents that whatever I'm getting an application for patent is not new. If nothing of such kind of opposition comes, I will always be getting the grant of the patents. So once the patent is granted, it will be for 20 years. Section 53 of the Act lays down that after the commencement of 2002, this will be for 20 years. So we can have joint inventors as well, and we can have single inventor also with respect to the patents. But there is technical document of provisional and complete specification is always very important, because that is something like the crux of your patents. It has the claims, it has the details, it has the what are the claims you are getting on your patents. See, we'll just take an example of single mobile or any other things. It will have innumerable patents in that. It has softwares, it has copyrights, it has design, and it has trademark. And when it comes to concept of patents, it has innumerable patents. So all those patents will be clubbed in one instrument, and that will be technically we'll be using as mobile or any other instruments. So what are those claims? For example, earlier, if you just take an example of mobile itself, what was the launching mobile in the beginning? That's a short one with keypad and not with much features. If you look into the present day smartphone, how it has been enhanced with all additional features, enhanced camera and RAM and all. And especially the concept of mobile, when it has started Nokia, later on it couldn't capture the market because it didn't understand where the mobiles will going to land in. And that's why all other smartphones with computer applications and the programs in the mobile started flourishing, and Nokia couldn't stand in the queue or in the line. Okay, so these claims are very, very important. How many claims in your invention? Is it 10 claims or 5 claims? You're asking for additional points. If it is not something of, you're going to foresee where exactly the things are going, how it will be going to stand after 10 years, whether my product will going to be in the market or not. So any inventor will going to keep these things in the mind and will going to have the invention. So when we speak of the particular aspects of specification and claims and all, once you have got the patents, once it is granted, you are the patent holder, you will be having certain rights. So as I told you, it's a property, it's an intangible property. You, as a property owner of a patent, you'll be given a lot many rights under the act as such. Okay, so that can be particular aspect of exploiting the patent, commercial exploitation. As I told you, you can exploit your patents. You can license the patent to another person. You can assign your rights to another person. If you don't want, you can surrender off your patents. And it is a particular, if there is any violation of your property rights, if anyone has used without your consent, your patents can always, as a holder, as a owner, you can file a sue. You can sue and you can get your remedies. That's for infringement. Okay, so when we speak of commercial exploitation of a patent means whatever patent you have got, if you are not using within 3 years of the grant of patents, anybody can file an application and ask for the taking back of the patents, and it can be given for someone else which is useful under the compulsory licensing. That's why rights of the patents are very important because you have to use it. If you are not using it, you please give it to others. You please give it to others. Let the others will going to manufacture. It means, for example, as a scientist, if I'm a scientist, I'm not interested in commercial aspects. I'm not good in calculations, profit motive and all. I can give it to someone else. I can license it to someone else. Licensing is always for temporary period. It's not for something long time. Or else, I don't want anything about the patents. I'm going to assign it for others. Anyone can take this. Anyone can take this and can encash and make and get it by paying the whatever the amounts to the patent holder. Okay, so this the concept of rights of the patent means if you are not using, you can license, you can assign. If you still don't want to give it to for anyone, you can surrender it off. You can surrender it off, and there is no need of you will be the owner and you can be involved in your inventions as such. Okay, so why we give the rights for the patentees means as you have put your hard work, you have to enjoy your fruits from your hard work. Okay, and what are there any obligations? Means yes, as a patent holder, when I manufacture anything, I should be knowing how it is useful. Is it useful? Means is it has it got any kind of demerits or any kind of other aspects impact in the society? All those things we have to keep it in the mind. Okay, so we have got certain exceptions and limitations when it rights for the rights of the patent holder, because government can take away your patents at any time if there is any necessity, national emergency, necessity and all. So at the time of necessity, government will going to take away your patents and you cannot say no for that. And government can give compulsory licenses and licenses of rights for others. And if it is of defense purposes and all, your patents can always be taken back. Okay, so that particular aspects, the patent and invention and rights will be going. And when we speak of these particular aspects of patent, as I told you, it's a form of property. It should be transferred. Yes, it can be transferred. As I told you, you can give it as a form of assignment, complete transfer of ownership, or it can be given under license, or it can be transmission. Transmission means your legal heirs under the operation of law, whoever is there, they can get the benefits. Assignment means yes, it's always we speak of legal assignment, nothing like anything else, because that should be purely in the form of writing with the terms and conditions, just like how we will have our contract and agreement. It should be in the same way, offer and acceptance and all the formalities of contract. And if it is any kind of equitable assignment, that will be always for shorter time and cannot be so. And even you can mortgage, even you can mortgage. Okay, so when it comes to license, we have got voluntary license, statutory license, and license something called express and implied. So we have got different ways of transfer of patents from the transferor, that is the patent holder, to the any other person. Okay, so this is with regard to the concept of patents, rights, and how the application and all those things. As I told you, it can be always revoked and surrender also. It can be revoked means if it is not renewed properly, if it is not paid properly, your patents can be revoked. Surrender means you don't want to have the patents, you can surrender it off to the government by giving notice to the controller and giving the reasons that you're not interested in it, and anybody, the controller of the patents and designs, can assign the rights for anyone for under compulsory license. Okay, so this is about rights. When you have got the rights, any other person cannot violate your rights without the permission. Without the permission means I have to seek your permission for reproducing it or manufacturing it or whatever commercially exploitation. I have to take your prior permission. If I'm not taking prior permission, that will leads to infringement. Okay, when we speak of infringement, we have got how, what is the level? Is it only slight variation, or mechanical equivalents are there, or immaterial variations are there? And have I taken is all the essential features or not? Because if I'm copying, is there something like should I whether I copied fully or 10% or 20% or 15% or 100% I have taken away your patents. So infringement of patents means when I have used your right without your permission and there is no question of uh, license or legal aspects, I am liable for infringement of patents. So that will be based, that is, damages or remedies are based upon what is your level of infringement. What is the level of infringement, and what exactly combination is there, or if just on the slide, on the note, it has been violated and all those things. Okay. So if anything of that sort or if anything of that aspect is there, when we speak of the patents, we will be giving the remedies for the violation of the patents. So when we speak of the remedies for the violation of the patents, as I told you, it's a purely property rights. For your violation of property rights, infringement, you can sue. You can file a sue. That sue, filing a sue is based upon 3 years under the Limitation Act. From the date of the infringement, it has to be within the 3 years. Who is entitled to sue means the person who has got a right, the person who is assignee, the person who is owner, who has got a license can file a suit, not anybody else. And what kind of remedies you are asking? Do you need of interim injunctions or interlocutory injunctions or damages? You have got damages of huge loss, so you can ask for the damages, and you can also ask for permanent injunction, where in which case you feel that there is a great loss to you. So all those things can be considered. But as a person, I can always defend. I have not infringed. I have not done anything wrong. I am innocent. I have done it out of ignorance and all those things. But if you want to defend also, you should have sufficient point to defend yourself that you have not violated the provisions of law. Okay, so that's an aspect when we speak of the aspect of patents and remedies and aspects. And here, when we speak of this, are this concept of softwares, comes under the definition of patents in India. What do you mean by that? Software patent or software copyright and software piracy. So when we speak of software patents in India, are all these softwares, computer programs, are patents? Certainly not. Because of our Copyright Act of 1957, Section 2, Clause O says, computer programs are protected under Copyright Act. And under Section 3 and 4 of the Indian Patent Act, what are not inventions? It says computer programs are not patentable under Indian Patent Act. So, computer data, programs as creative work entitled to copyright protection, and all those falls under computer program definitions are considered as literary work in India under the copyright protection. So, Copyright Act of 1957, we speak of computer programs and all the aspects of literary work, which is a different form of expression, different form of expression under Indian Copyright Act. Okay, so literary work, as I told you, it includes computer programs and its compilation and all the aspects. Then what is this, the concept of piracy? All of us have heard about piracy, musical piracy, biopiracy, and like that, it's about software piracy. Software piracy is the unauthorized copying or distribution of copyrightable softwares. So here, you are not the owner, you are not the legal owner, legal having assignment or any kind of that particular aspect, but still you are eligible for the, you are doing this particular violation of the computer softwares, and it is used without the permission of the owner. Okay, in India, provisions as to software piracies are covered under Indian Copyright Act, now inserted by the Amendment Act of 1994, and we speak of this knowing use. Knowing use is always important. I know it is not, it should not be, but still knowingly I'm using infringement copy of computer program to be an offense. Any person who has done this are committing the particular concept of infringement, or I'm sorry, software of piracy. Okay, so this is with regard to softwares and copyrights, and as it is not under the definition of patents. It's not under the definition of patents, but when it is patents, I mean, when are the softwares are installed in the particular instruments and all, then it is different perspectives. As generally the concept of patents, softwares and computer programs and its compilations will not come under Indian patent law. Okay, so and the other aspect, what we have to think about patents when we are learning about patents is that this particular patents, the concept of patents and international recognitions. As I told you, this particular knowledge, now what knowledge economy is there? Earlier it was power economy and now it is knowledge economy. There is no question of any kinds of violation, and it's always purely knowledge, and knowledge is empowered and more powerful. The country which is rich is that the country which has got more patents. The country which is strong is that which has got more intellectual property rights. It's not like earlier concept of power, it is now the dimension is different. So with respect to these patents and international aspects, we have got our international conventions. When we speak of the patent laws, we have we'll start from Paris Convention, and when it is an aspect of IPR, we have Paris Convention, Berne Convention, and Madrid Convention, PCT, and finally WIPO and TRIPS. But when it is aspect of patent, we speak of Paris Convention and we speak of PCT, and the particular WIPO now present, World Intellectual Property Organization, for the protection of all our property rights of IPR, and finally TRIPS. So TRIPS is something very crucial and important at the present scenario because it has occupied the whole world. What do you mean by this TRIPS as such? So TRIPS, as the definition meaning itself says, trade related aspects of intellectual property rights. What do you mean by trade related aspects of intellectual property rights means? See, after the establishment of TRIPS, that is 1st January 1995, it started working of TRIPS as such, and India is a signatory. And as India is a signatory, India has to comply our patent laws along with the TRIPS agreement. That's why we have amended our Indian patent law, and it happened thrice, once in 1999 and 2002, and finally in 2005. So we have compiled with our patent laws along with our TRIPS agreement. But when I speak about the concept of TRIPS agreement as such, It is a particular trade related aspects of TRIPS is always important. What do you mean by this trade related means? As I told you, IPR is not a local or it is a national one, it is an international aspects. What kind of property transactions, international trade can happen between two countries? Trade can happen between multilateral countries. Trade can happen between the continents. What was earlier was purely local, used to buy here only our local items and all. Now we are having multiple choices, opportunities, which are giving list of opportunities, says about what exactly we can buy, which is good brand and which is from which country and how long it is durable, whether it is okay or not, additional features. We always think about all those features. That's because it's possible because of the all this international trade and all. So we are very flexible. The world has become a global village. All the products are available for everyone. Any earlier, whatever the good products of the foreign countries which used to come to India through smuggling and smuggled goods and used to sell by not open markets. Nowadays, everything is available everywhere because this TRIPS has got, we have got agreements with other countries, and through PCT, if your application is filed and your application is protected worldwide through the PCT countries and nations, and you'll always be getting protection for your property rights. So it has reduced the burden, it has helped the person, it has helped the person for giving more recognition, and also he is getting more paid for his hard work, and benefit is also more. So when we speak of the particular aspect of patents as such, we can never say anything like it has been produced here, it has to be sold here only. But when we speak of the license and all, it is purely, for example, if an Indian product has to be sold in foreign countries, those people should have got a license or they have got a assignment. Something of that agreement, if it is not there, we cannot have any kind of particular aspects of patent protection at the international level. So when we have this particular rules and guidelines, we have to look into TRIPS agreement, TRIPS guidelines, and all the particular TRIPS guidelines will going to help us to know properly how the agreement between the two countries will happen, between the continents will happen, between the other multilateral countries will happen. So we have to keep in the mind that when we speak of the concept of TRIPS agreement, member countries make patents available for any inventions, whether for products or process throughout the TRIPS member countries. So TRIPS will always help us to expand our business, expand our inventions. And as I told you, patents are only for 20 years. Patents are 20 years means after the 20 years, it will be into public domain. You cannot think of it continuing the same thing. You should go for further one. And basically, when we speak of 20 years, they will not get 20 years to enjoy. By 3 years, by 4 years, another person will come out with another invention, and another competitors will going to come. Another establishments will going to occupy the market. So in that particular aspects, when we speak of the patents or at the international level, we have to look into, we have to be ready for that particular competition. That should be free from unfair practices, and we should be able to compete at the world global level to get our whatever benefits and commercial exploitation. Otherwise, it's not that easy. But TRIPS and WTO and all the international regulations have helped us to modify and make our trade communications and commitments between the nations easy and possible for all the member countries to make as much as commercial exploitation of their patents. If it is not so, if a person who has put his hard work will not be supported, or will, if it is not given any kind of privileges, any kind of increments, who are the people who will come forward? How can we have more and more of scientific research and development, right? So this particular aspect of inventions, which has to be supported and promoted, That's why Government of India has got a huge and very good policies of Make in India, Think in India, and whatever the policies are making the people to go for innovative new ideas and start with their business or any kind of industries with the new ideas. And Government of India, especially Make in India, is giving subsidies, huge amount of IPR policy supports huge amount of subsidies and the funds for any person who comes innovative ideas and starting any kind of new industries. And we are also helping them financially with the policies and infrastructural benefits also, so that together we can make India much more strong and suitable for the global level. So this is purely now government is promoting, and that's why everywhere, this is one of the reason why IPR was introduced everywhere. And IPR, now we have got exclusive IIT Kharagpur and all, where we speak of pure aspects of IPR, that is BSc LLB, wherein which case you will be getting degrees in IPR, because it's an intention to support more scientific research and innovation, so that we will stand in the respect of scientific research more and more. That's the reason we are supporting for research. That's why government is spending huge amount of money for all these things. Any related aspect of IPR, standard authenticated information about the policies and aspects, it is always available under www.ipi.india, gov.in. But when it comes to patents, as I told you, what are the avenues? If you look into the concept of patents, you can be patent agents, patent attorneys, and patent agents. The students or anyone who has got a background of science, good knowledge of science, and with a degree, they can practice. They can practice and take the examination of patent attorneys and agents. By passing the examination, you can practice in the field of patents. To practice in the field of patents, you should be should science student to understand the complications, intricacies, and the almost all the aspects of the science. If it is not so, it's not that easy to defend your claims when it comes in the matter of tribunal and all. You cannot defend. You cannot say whether it is modified, whether it is altered or just modified or additional features, what kind, it is not easy to understand. So that aspect, we always keep science in the mind of us, and we're going to make this. And recently, I think not recently, by next month in Bangalore, Indian Institute of Science, we are having one day workshop with respect to PCT and Indian policy, and how it should be filed and how it should be approached, and what should be the uniform method of getting protection throughout the patent cooperation treaty, throughout the members of this particular PCT. And this is happening at Bangalore, this is happening at Delhi, and as well as at Trivandrum and Hyderabad. Why we are doing all these things? More awareness means the particular concept of patent, though it is technical. Of course, I am speaking from the point of law aspect as such, but when we look into the particular aspect of science and knowledge and new policies and new cracks and idea, that should be always promoted, and they should give the incentives and privileges as a matter of right for their hard work and labor, and it has to be rewarded. So, patent as a form of intellectual property rights is something very crucial and important for any person, because he has put all his hard work, all his labor, and that should go to him, and he should get the benefits of commercially exploiting whatever that particular property rights. If it is not so, I don't think so we'll have much more developments in science and development. That's why Government of India at the state level also it is doing, at the union level also it is doing, and international levels we are having tie-ups with other foreign countries, where in which case countries like Japan and all, China are running with new varieties of patents, and new patents are coming into the mainstream, and they are getting the benefit. So to compete to that level, Government of India is trying to do all these things to support and make stable when it comes to matter of science and inventions. So we can look into that particular website, and you can also look into intellectual property policy of Government of India, and under the Niti Aayog also we can look into the think tank policy of IPR and the Make in India policy of IPR, and all those aspects are linked and interlinked with, especially towards patents. Especially towards patent because it involves huge amounts of research, knowledge, invention, and labor, hard work, and that labor is not something forever. It's always for short time. So that particular person should be rewarded. Thank you. Thank you so much. If it's any questions, we can answer.
Good evening, ma'am. This is Martesh here from Vivipuram Law College. I have one question. You talked about patent and you give a
Pratibha,
brief idea about brief idea about patent.
Yes.
Yes.
Ma'am, are you able to hear me?
Martish,
Yes.
Martesh at GS is speaking. Ma'am, I'm a
ಸ್ವಲ್ಪ ಲೌಡ್ ಆಗಿ ಜೋರಾಗಿ ಮಾತಾಡಿ.
ಓಕೆ, ನಾನು ವಿವಿಪುರಂ ಲಾ ಕಾಲೇಜ್ ಸ್ಟೂಡೆಂಟ್. ಈಗ ಕೇಳ್ತಾ ಇದೆಯಾ?
ಎಸ್ ಎಸ್ ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
ಇಲ್ಲಿ ನೀವು ಪೇಟೆಂಟ್ ಬಗ್ಗೆ ತುಂಬಾ ಚೆನ್ನಾಗಿ ಹೇಳಿದ್ರಿ. ಒಂದು ಬ್ರೀಫ್ ಐಡಿಯಾ ಕೊಟ್ರಿ ಹೇಗೆ ಪೇಟೆಂಟ್ ನ ಕೊಡ್ತಾರೆ ಅಂತ. ನನಗೊಂದು ಪ್ರಶ್ನೆ ಇದ್ರಲ್ಲಿ, ಈಗ ಪೇಟೆಂಟ್ ಅಂದ್ರೆ ಈಗ ನೀವು ಹೇಳಿದ್ರಿ ಪೇಟೆಂಟ್ ಕೊಡ್ಬೇಕಾದ್ರೆ ಒಂದ್ ನಿಮಿಷ, ಈಗ ಪೇಟೆಂಟ್ ಕೊಡ್ಬೇಕಾದ್ರೆ ನಾವಾಲಿಟಿ ಇರ್ಬೇಕು, ಮತ್ತೆ ಆ ನಾನ್ ಆಬ್ವಿಯಸ್ನೆಸ್ ಇರ್ಬೇಕು, ಆಮೇಲೆ ಇಂಡಸ್ಟ್ರಿಯಲ್ ಅಪ್ಲಿಕೇಶನ್ ಇರ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ರಿ. ಈಗ ಇಂಡಸ್ಟ್ರಿಯಲ್ ಅಪ್ಲಿಕೇಶನ್ ಅಂದ್ರೆ ಓನ್ಲಿ ಫಾರ್ ಕಮರ್ಷಿಯಲ್ ಯೂಸ್ ಆರ್ ಸಮ್ ಅದರ್ ಯೂಸ್?
What do you mean by some other use?
ಈಗ ಕಮರ್ಷಿಯಲ್ ಯೂಸ್ ಅಂದ್ರೆ ನೀವು ಕಮರ್ಷಿಯಲ್ ಅಂದ್ರೆ
ಸಮ್ ಅದರ್ ಯೂಸ್ ಅಂದ್ರೆ ಏನು ಅಂದ್ರೆ ನಂಗೆ ಅರ್ಥ ಆಯ್ತು ನೀವು ಹೇಳ್ತಾ ಇರೋದು. ಕಮರ್ಷಿಯಲ್ ಯೂಸ್ ಆಗಿರ್ಬೇಕಾ ಅಥವಾ ಸಮ್ ಅದರ್ ಯೂಸ್ ಆಗಿರ್ಬೇಕಾ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀರಾ. ಸೊ ವಾಟ್ ಈಸ್ ದ ಡೆಫಿನೇಷನ್ ಆಫ್ ಸಮ್ ಅದರ್ ಯೂಸ್ ಅಂದ್ರೆ ಏನರ್ಥ?
ನೀವ್ ಹೇಳಿದ್ರಿ ಬರೀ ಕಮರ್ಷಿಯಲಿ ಎಕ್ಸ್ಪ್ಲಾಯ್ಟ್ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ರಿ.
I mean to say any invention, if it is a new product, okay, new whatever you have invented, that should be capable of industrial application ಅಂತಂದ್ರೆ industrially manufacture ಮಾಡೋ ರೀತಿ ಇರಬೇಕು, not just a formula based one, okay, not just a formula based one, and it should be commercially exploitable ಅಂತಂದ್ರೆ whatever hard work invention I have done it, that should be able to reap me some benefits or any rewards. ಅದರ್ ಯೂಸಸ್ ಬೇರೆ ಅದರ್ ಅಂತಂದ್ರೆ ಏನು ಅಂತ ನಂಗೆ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ, ನೀವು ಯಾವ ಆಕ್ಸೆಲ್ ಕೇಳಿದ್ರಿ ಅಂತ.
ಅಂದ್ರೆ ಈಗ ಅಗ್ರಿಕಲ್ಚರ್ ಯೂಸ್ ಮತ್ತೆ ಬೇರೆ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಯೂಸ್
Okay, okay, I'll tell you. See, agriculture and plant varieties and all the aspects comes under different forms of IPR. You will be studying IPR in detail, especially with related to biological diversity and CBD, Convention on Biological Diversity. And you'll also be studying about what we speak of the seeds and breeders' rights and farmers' rights, and all those things are also part of IPR. That you will be studying in a different perspective. There we call it as biopatents. So biopatents are different. Here these patents are different. So biopatents where it involves biological resources. Biological resources, especially if it is from the biodiversity, that is our biodiversity. Or else if you are a farmer, if you have invented, I mean, you have got any kind of new varieties of seeds, new varieties of plants, then also you are coming under another segment of IPR, that is Plant Varieties and Protection Act, not under the Indian Patent Act, that is not under the patents. So patents are different, biopatents are different, and the plant varieties are different. So when we are taking the concept of agriculture, agricultural processes and methods are not inventions under Indian Patent Act. That is under section 3, they are not called as inventions. So you will be studying those under another segment called biodiversity and plant varieties, not under patents. Okay, so if you have done hard work of having an invention, can you just sit back and say that I will not exploit it, commercially use it, make money for your next further invention? Or any scientific company or any company, if they are putting huge amount of money, do you think after making the invention they'll just keep quiet? They say it's okay. No, they would have put the money with expectations of worldwide making the profits, using of it, or else whatever the hard work they have put, that has to come back, no? Right?
That means there is no criteria for it must be a commercial exploitation.
No, see, if you are taking agriculture and all those things, that is also commercial, but under different segment. So here it should be exploited. Exploited means it should be capable of using it. It should be capable of application it. It's just a formula. What's the use of it? See, I'll say I have invented something. Wow, very good, nice. Can it be reproduced in industry? If it is not so, that is not full-fledged invention of whatever I have discovered, whatever I have invented. So if I have invented means that should be outcome. Product should go to the people who are in need of it, right? See, for example, Corona time, the vaccine has come. Okay, but still we have got it at concession. Government has given it very less, so whatever, free and all, because that's an exception for the rights of the patent holder, where at the time of the emergencies your rights can be taken away. But that is also exploitation of patents, making into much more availability for all the needy throughout the worldwide. India has supplied. India has supplied for all. Okay,
Thank you, ma'am.
thank you so much.
Madam, there is one more question from the participant.
Yes, ma'am.
Pradyumna B. Ravi is asking the question, how is a patent specification prepared?
Okay, patent specification prepared is purely, it's a technical document. As I told you, it's a technical document means as a layman, as an advocate, without having a background of patents and science, you cannot prepare specification. When you are preparing specification, you have to take the help of any advocate who has got a background of science plus patents knowledge. That is, as I told you, we are having IIT Kharagpur and all. They are experts if they are coming basically on LLB engineering. That is LLB and engineering clubbed. So if you are drafting any claims, specifications, it's as I told you, it's a technical document. I have to specifically say about what. First one, about what you are doing, about what exactly you are speaking of the patents. What is the brief description? See, for example, if it is any new product, you can take an example. See, I had, as I told you, I had prepared particular slides, wherein which case of 1930, 1830s, the particular first hair dryer, how it was there, the parts of it, how it was there. They will go into segment with clear claims. See, I am using this product, I am getting so many claims. Claims means it's nothing but additional points which was not there in the earlier product. I have given you earlier example of Nokia old phone and the present smartphone. We can easily identify what are the special features here and what was not there. Why did Nokia lose the market? So specification is filed always along with an application by a true and first inventor. First, protecting his property rights of patents, and next he will going to start the research. For example, I'll get an idea. As a scientist, I'll get an idea. I'll start with the research. I'll go on with the research. Slowly, I'll be getting much more diversified views. My claims can enlarge. It can add it also. And later on, I will submit in the complete specification. So it's not a layman easy job, not even an advocate, but it is basically by a technical experts who are experts in the particular IPR. They can only draft this specification. We have to take their help and draft it.
Okay, madam. Thank you, madam. Ma'am, there is one more question from the participant. How to be a patent attorney or patent agent, and regarding its exam, they are asking, ma'am, whether there is any examination with respect
Yes.
to become a patent attorney or a patent agent.
Yes, actually, if after this class also, whoever is asking the question can log into the www.ipi.india, where in which case date has been extended for applying for patent attorney exams. So patent attorney exams means you are applying for that exam, taking the exam, and after passing that particular attorney exam, that is agent exam, you are capable, or I mean, you are able to take any cases relating to patents throughout India. I mean, you can appear. For example, as an advocate, LLB is necessary for us to appear before the court. Like that, patent attorney exam will going to make you to appear before the patent cases or IPR cases to handle the cases more confidently and technically. It's something like without that, you cannot appear before the exams. I mean, appear before the IPR tribunals. That's a qualification, kind of qualification or examination to be passed. It has got exams. Anybody that can log into that IPI website. The date has been extended, and basically you should be a science plus LLB. It's not anyone without science. It's not possible for them to pass this patent attorney. Don't say this is discrimination and all, because basic science is required for anyone to be in the field of patents. So as we see, we always look from the point of the law, but from the point of science is very important for anyone in the matter of patents, especially drafting of claims. Technical document, as a layman, I may put only 3 claims. As a scientist, patent attorney, he can put 10 claims. So 10 claims, I'll get more money, more aspects. I hope you're satisfied about the answer. You can look into the website. You'll get much more scope about that.
Okay, madam. There is one more question from the participant. They are asking about what are the career opportunities for BSc LLB students in IPR.
The BSc LLB itself is wonderful. I should say that. BSc LLB means wow. Nowadays, we are not having BSc people only. Basic science people are not going at all. See, if you are well versed in BSc LLB, you don't want anything else. You can go in the practice of an advocate generally, or you can move in the field of working for IPR firms, especially for huge number of MNCs are working in the aspects of patents. Huge, it's not 1 or 2. MNCs are working in the aspects of patents. You will be taken as research associates. And I have visited 2 or 3 companies when I was doing my research on pharmaceutical industries. Pharmaceutical industries are having avenues and scope with respect to this particular who have got BSc LLB. You are good in science as well as from the point of law. So you can draft claims, you can protect your policies towards your company. So it's always nice, and you have got multiple opportunity along with general advocate, otherwise also. Worldwide, the worldwide opportunities are there. I'm not speaking of an aspect of only in India as such. Worldwide opportunities are there. Okay.
Okay. Thank you, madam.
Any other question?
Is there any other question from the participants?
Madam, I have a question.
Yes, sir.
Myself, Manjunath. I'm from first year LLB 3 year from Vivekananda College.
Okay.
Actually, is there a chances that two invention happening simultaneously at different geographical locations? How to deal with it?
It may be possible, because 2 people cannot do same invention at simultaneously same time. It cannot be no. It can be yes. It means that it can happen. One in Karnataka it's happening, or one in Andhra is happening simultaneously. It might have happened. It might, but who is applying first? Who is getting first protection? Who has applied with the specification and application will get the protection, not the second one. Not the second one. And if they have both of them have applied same time, then that is different issue that has to be debated, and it has to go to the court and prove who is the first one. But it can happen. It can always happen. Anytime, anywhere, research can happen. Many times it can be like this. For example, I have started research. Somebody might have leaked the information for any other company. Basically, it happens at the company levels. It can happen. And if they'll get to know, they can expand it or alter it and modify it and make a new further invention with additional one. So at that time, who is applying first with abstract, that is the specification, will be getting the protection of IPR, and not the other one who is doing the afterwards. Same day you can apply. Same day you can apply for the specification, provisional specification, but when you will going to complete specification will decide who will going to get the property rights, whether it is you or whether it is somebody else. So it can happen. It can. There is no bar that other person is doing, I should not do. No. Government of India is giving all the facilities. Think new. Think have new policies. So we are promoting all inventions. It can always be possible.
Because we have seen in the cinema industry, the songs are being copied and leaked, and it is being broadcasted by someone else. and they're telling it's our song, someone is telling it's our song.
Okay,
And
okay.
suppose
Let me tell.
suppose the copier goes and register first. What about the person who have put in hard work for a long time and he is
Okay,
losing his credibility?
okay. See, this is the concept of copyrights. Okay, this is songs. Songs is a different form of expression of IPR. Songs comes under musical form. It is copyrights. That's not patents. There is no invention of songs. It is an expression. It's an expression of an idea in a different form. Article 19, clause 1, clause A. How you are expressing. So that is, songs is different. Songs are not covered under Indian patent law. It is, as I told you, under section 3 and 4, all the copyrights are excluded. That will be protected under Indian Copyright Act, under the musical forms, dance forms, artistic forms, drama, theater, everything is there. Everything is the performance rights is there, and we have got bunch of rights for your expression, for your whatever delivery of your expression in a mode and whatever the manner. So that is not covered under the particular aspects of here patents.
Thank you so much. That was a nice session.
Thank you so much.
Madam, could you please tell us about the priority date in the context of patent law?
Yes, ma'am. When we speak of the particular patents, when you are filing an application, it's the date of the application is always important. Date of application is always important. When did you file? So that is with your technical abstract of specification, provisional specification, and not complete also. See, for example, if we both have filed on the same day, I might have filed in the morning, you might have filed in the afternoon, I will be on priority than you. Temporary. But when it comes to the aspect of completion of the patents, if we both are doing the same one, same invention, as you someone was asking, then who will going to complete it is always important. It's me or whether it is you. So it means always the filing of an application is important. That's what I told you. You don't wait till the complete specification. As soon as we get an idea of putting things abstract and going an idea, instead of leaking of that particular information for others, start filing an application. Put an application, it will be there in the patent office, and you can complete by the complete aspect of complete specification, and you may expand your ideas. You may get much more. As we start doing research, we'll be getting different dimensions. So that will be different aspect, but your application date is always important. The date of filing.
Thank you, madam.
Thank you, ma'am.
Madam, is the agricultural research are covered under this?
No. Agriculture researchers are not covered under Indian Patent Act. As I told you, section 3, it has excluded agriculture methods from the concept of inventions, and agriculture methods or agricultural research, all those will be coming under Biological Diversity Act and Plant Varieties Protection Act. So that you will going to study with respect from the perspective of biodiversity, because there it is the nature we are taking, environment we are taking, biological resources we are taking as a raw materials. So raw materials are from the nature or from the forest or from the lands. So that is particular biopatents. For example, your turmeric patents, neem patents, basmati patents, all those things are patents, but biopatents, not the patent concept. That will be studied in the different dimension and perspective, and the new seeds, farmers' rights, what are the farmers' rights, how can they make, and all those things they can look into that. Hello? I think it's satisfying. If you can look into that, because you can go to CBD, Convention on Biological Diversity, and India also we have got an act of biological diversity, how to protect the biological diversity, and farmers' rights, and owners of the particular companies with respect to protection of seeds. Seeds means whatever the new seeds which you have invented, that will be coming under the Plant Varieties Protection Act. And it has got its own international conventions, guidelines, protection, which is there under TRIPS as such.
Thank you, madam. Well taken. Thank you.
Excuse ma'am.
Yes.
Excuse ma'am. Myself Madhav. I am from final year student, ma'am.
Okay.
Ma'am, what in case if a person got a geographical indication somewhere else another person has filed a patent over that product?
Okay. See, you're clubbing two forms of IPR as such. GI is totally different and patent is totally different. And as I told you, GI is only for that particular geographical area and no question of mixing with the patent as such. For example, I'll give an example. We'll speak of Alfonso mango of Nagpur, and we'll speak of mango from Coorg and mango from Nagpur. So both are from that particular locality. If you grow Nagpur mango in Coorg, you don't get the same taste because GI means of that particular geographical area, weather, climate, and whatever the environment, water will all give the additional qualities for the particular product. It can't be just like that. It can't be like an invention. Invention is wherever you make the invention, ultimate result will be same. But GI is not like that. We can grow the foreign products in India, but the taste, quality, and all will not be same. And that particular climate is suitable for growing of that particular products. That's why mango, I mean, or any kind, we have got innumerable varieties of mango. We have got varieties of orange, or as we call betel leaf from Mysore, and flowers and other examples. Because of the area, because of the geographical culture and that smell, that particular characters will be there in the products. That cannot be confusion with regard to patents at all. It's a totally different concept. It has to be understood in a different perspective from the point of area. For example, which area? That particular GI. And very thin line, not thin line, major difference between them is that if you're having GI, no other person can get a protection other than the localites. Other than the localites means, for example, Unkalmuru sari manufacturing people have an association of sari weaving at that particular pace. That is Kanjipuram also, Kolkata also, Bihar also, Tussar silk and all the fruits of that particular area. Shimla apple growing association. And there only it is different. So they don't have any kind of confusion because other third person cannot file an application only for GI. They'll not get because you're not from that locality. So you will not be getting. And GI is a community right. Community right means whoever the people involved in that business of manufacturing or of particular growing or of weaving or of the product or of the final product, only they will going to get, not the new person. New person or any person can never enter into that particular community where they are involved. Okay, but patent anywhere else, you manufacture the same thing in foreign, manufacture the same thing here, the product will not change. It has to be same. That's what is the patent. Okay.
Okay, thank you, madam.
Yes,
Ma'am, there is one last question from the participant.
yes,
They are asking about the career opportunities for the one who has done BLLB.
BLLB is also like much more vibrant than BSc LLB. I think BLLB means basically whatever kind of LLB, I mean BE you got. You can be civil engineer or any other person, whatever it is. But if you are interested in an aspect of IPR or general practice or any kind of attorneys, it depends upon you. See, our Karnataka State Biodiversity Boards hires people, and plant varieties authorities hires people, National Biodiversity Authorities hires people. So all these particular people take people from technology, people from law. If you have both the qualification in one person, it is always additional advantage of enjoying both the profession. How passionately you can make use of it, you can make use of it. Especially all these boards, especially plant varieties and biodiversity and patents and all the, they're and all policy framers and makers and particular experts. They expect from someone who is good in science, who is good in BE. Because we can also look into when we speak of this Indian Forest Service exams, we exclude others. We don't take other than the science graduates. So it's not a discrimination, it's the preference is given. So like that, BE LLB is always having good scope. How well you can take it, just practice, well and good. Where you want to practice, which field you want to practice, that's also your choice, your passion. It should be your passion, then only you can enjoy. Any other question?
Okay, madam. Thank you. I will proceed with vote of thanks.
Yes, ma'am.
Thank you, madam. Okay, it has been our pleasure to hear Dr. Kavyashree, an Assistant Professor, Government Law College, Ramnagara, at length on patent law. I am delighted to express my deep gratitude on behalf of our institution to Dr. Kavyashree. We profusely thank you for the lucid lecture. Thank you, madam. We look forward to many more sessions with you in future. And it is my pleasure to thank all the distinguished participants, especially Dr. Vidya Shettaman, our Assistant Professor, KPEC Law College, Dharwad, Dr. Ashwini, Assistant Professor, STM Law College, Mangaluru, Archana PS, Assistant Professor, Arunodaya Institute of Legal Studies, Bengaluru, and Damodaran Sanjivaya, National Law University, faculty members from different colleges, alumni, and student friends for making this webinar a grand success. Thank you one and all. And tomorrow we look forward for all of you to join us for another session on trademark law at 6 p.m. sharp. Thank you. And participants, please fill the feedback form provided in the chat box. Thank you one and all. Thank you, madam.
Thank you.
Thank you,
madam.
madam.
Thank
Thank
you,
you,
madam.
Thank you
Kavyashree,
for
madam.
Yes.
wonderful
It was a
session.
very wonderful session. Thank you, madam.
Thank you, ma'am. Thank you so much. Thank you.
Yeah, we can ask
Pratish to end the
Pratish
meeting.
to end the meeting.
Yes, Pratish.
Pratish, ಅವರೇ ಇಲ್ಲ
Pratish, you
ಅನ್ಸುತ್ತೆ.
can